Good morning, Tom.
Good morning. May it please the Court, Dana Curhan representing Leroy Sanford. With me is Adriana Contratesi. There's no question that there was a serious discovery violation in this case, and there's no question that the evidence, the potentially lost evidence, was material.
But how were you prejudiced?
Well, we don't know what the detective did to get this gun to fire. We know that there was some very serious physical contortions that had to be made to get this gun to fire. We don't know what happened the first time it was tested. We don't know if if in inserting this cartridge, this magazine, whether any kind of alteration was made the first time it happened.
Did he prepare a report?
I'm sorry?
Did he prepare a report?
He prepared a report that was very vague. The only thing it said is the gun fired. And it did say that there was a Smith & Wesson clip and a Star 90 or whatever it was.
Something. Yeah.
So why should there not be an evidentiary hearing with him testifying in which you have an opportunity to learn from him exactly what he did do? And then maybe bar the first test from evidence and then determine whether or not, if he's credible, you're in a position to essentially evaluate whether it was operable based on that testimony.
Well, two things. I mean, number one, we probably don't know what he did other than what the defense expert observed when he saw the second test. And I suppose an evidentiary hearing might get to that. But number two, when Detective Camper may not know whether putting in this magazine from this non-compliant magazine actually altered the gun or bent something or moved something or caused it to be able to fire.
Somebody look at it and, I mean, presumably you can get access to have it examined to see whether there's something that, I know they can't tell you who did it or when, but could tell you whether any of the internal workings were altered in some way.
I'm not sure if we can ever determine that.
But isn't that your burden? Don't you have to show that either through a metallurgist's testimony or some testimony that this gun was altered in such a way that made it fire and it otherwise would not have been able to fire?
Well, I think we have to show a reasonable possibility of that fact, but I think we showed that. In order to get this gun to fire, normally what you do is you take the clip that's made for this gun, you put it in, you move the slide forward, and you shoot it. Mm-hmm. What they had to do is take a cartridge out, manually load it into the gun. Of course, there's a safety. If there's no magazine in, the gun won't fire, but they didn't have the magazine for this gun, so they took the Smith & Wesson magazine and sort of jammed it up there, and once that happened, the gun was able to fire.
Yeah, and release the safety with that.
Yes, that released the safety.
But none of us, or I mean, not just us, I mean, no one would know, except probably an expert, whether in manipulating the gun in that way, you do anything to it, or whether it can just be done again and again and again.
Well,
Your expert doesn't really get close enough to that.
I'm sorry?
Your expert doesn't really get close enough to that or cross the hurdle of saying, yeah, this resulted in an alteration that produced a gun that was now able to fire.
I think the problem is that may be correct, but I think the problem is that we can never tell. I don't think we can ever tell whether there was any kind of alteration made to get the gun to fire.
But can't you ask the person who did the test at an evidentiary hearing?
I suppose we could, but I'm not sure if we can actually get an answer. Because
what do you mean if you can get an answer? You asked the question you just posed here.
Well, if he did something other than, say, put pliers in and bent the firing pin or something, he could tell you that. If he chose not to tell you that, we'd have no way of knowing that.
Well, you're making quite a serious accusation.
Well, that's what the judge found. The judge said there's nothing. We don't know if there was something done to that gun that has not been disclosed.
But you're saying something else.
you're saying that when you ask the person who did the test, that you're assuming that that person won't tell you the truth.
Well, that's what the judge seemed to imply. But I think there's a second point, which is that when he did that, he may not know. He may not know whether jamming that thing in there made an alteration to the gun, and that's also what the judge found. And I don't think an evidentiary hearing is necessarily going to answer that question.
Well, then how would your expert have known if he were present?
Well, because he could examine the internal workings
So
of the gun.
can he examine it now?
Well, he can examine it now, but he has no way of knowing what the condition of the gun was originally. That's the problem.
Well, could I just ask you a
Yes.
separate question? From your expert's report, there was a mention that in the arrest report that he received, that I didn't see in the record that we have, there was no magazine listed at all. And so my question is part of your argument that if you had been there the first time around, you would have seen the gun and would have known that there wasn't a magazine there? In other words, is part of your issue, you don't know whether Detective Camper sort of brought the Smith & Wesson magazine to use in this way? I couldn't tell what the relevance or whether you were making anything of the fact that your expert says that the arrest report didn't list a magazine.
I'm not sure where the Smith & Wesson magazine came from this record. I don't have any specific information.
But you're saying, I take it, that the gun as it existed at the moment it was seized was not operable, was not fireable, because it didn't have a magazine, and I
That's
guess
right.
B, there was no bullet in the chamber.
There was a bullet, I think, in the chamber.
Well, I think that was the whole point. What was represented at the hearing, there was a hearing. It was not an evidentiary hearing, but what was represented is we take the position based on the counsel said, I can't tell you exactly how I know this, but as an officer of the court, I'm saying this gun is not operable. That's why we have an expert here. That's why we wanted the testing done.
And it wasn't operable because, at least for the reason that it did not have a magazine in it.
Certainly that.
Yeah.
But I think the position went farther than that we contend that the gun was not operable as it was.
And I take it that contention, as you were suggesting, was made right at the beginning, indeed. That was the very reason why this motion to preserve the weapon and to insist that the defense expert be there when it was tested. That's the reason that motion was filed.
Exactly.
That was the defendant's position from day one.
That was the defense position from day one.
Now, should we examine this a little differently than the sort of Williams examination because the judge found this, imposed this, or excluded this evidence under Rule 14C? In other words, this is not just a case of lost evidence. This is something a little different. It's a discovery violation, a very specific discovery violation involving a material piece of evidence, and the judge essentially acted under Rule 14C to say, I have discretion as to whether to exclude this evidence, and I'm so acting.
Well, I think that probably makes sense.
But does it make a difference in how we think about this? Is this just a lost evidence case where we just do this balancing as sort of set out in Williams, or is there an overlay here of something else, some other layer of discretion that we need to consider?
Well, I think the judge does have discretion to remedy a discovery violation. In a civil case, of course, the Commonwealth would be out in its ear right now. I mean, this is a pretty serious and egregious violation, and I think that probably brings me to the issue of culpability, which the appeals court essentially said it's mere negligence, so we don't even have to talk about culpability.
Yeah, but you have to. I mean, I think you have to deal with. You have to accept Justice Cordy's view, because to get to culpability, you've got to get to, I think, the fact that the judge, within his discretion, said that you had met the Neal test, so that then we get to the three culpability, the other two points. So you need that discretion, don't you?
Well, I think you need the discretion. I mean, I think Williams actually covers it pretty well. I mean, Williams says, if you make
Williams
it...
was a case in which the judge denied the motion to suppress, and so the evidence came in. The trial judge then did some things to
mitigate it.
mitigate it. But it was discretion used the other way. I mean, if it was...
It was discretion used the other way, and it made perfect sense in that case. But I think in this case, there's a very clear possibility that there was exculpatory evidence that was lost. And Detective Camper, I think, was a little cute when he wrote a report saying, the gun fired. Yes, it said in the report, it said in his certificate that a Smith & Wesson clip was used, but it didn't go through all of the manipulations he had to do in order to get that gun to fire. That kind of came out on the second test.
But I'm sorry I hope I'm not beating a dead horse, but I guess I remain with this question. The only place I saw mention of the fact that the arrest report didn't list a magazine was in your expert's affidavit. I didn't see it argued. Do you just not make anything of that? Or is that, I just don't know what you're doing with that, if anything.
I'm not sure what the status, I'm not sure where that clip came from. And I really can't represent on the record where that clip came from.
Well, it wasn't seized.
We don't know.
We don't know. I mean, the Commonwealth may know more than I do.
Well, I thought there was a reference on page RA-19. It's a reference to a silver medal magazine.
Yes, there was one in what went to the fingerprint people, but your expert says the arrest report I got didn't list a magazine, so that's really what I'm
not sure if I can clarify anything more than that. I really don't know the answer to that. But let me see if I can move to culpability.
Before we get there, the assumption here is that this fits into the Williams lost or destroyed evidence, but it's only lost or destroyed evidence if the gun was indeed altered in some particular fashion. So aren't you assuming, I mean, how do we know for sure that this was lost or destroyed? Williams was DNA, which was used up and couldn't be retested. Why do we know that this firearm simply is not essentially in the same condition it was when it first went there and can be retested?
We don't know for sure. And we'll never know for sure because obviously the gun was in a condition where it could be fired by doing all of these manipulations. We don't know the condition, what condition it may have been in before. And Williams does not require, and some of the other cases do not require certainty, but at least a reasonable possibility that of an alteration.
Well, do you have any, is there any other case? I mean, in the other cases, to my knowledge, it was either lost, it's just gone, or, like the DNA, it was destroyed. I mean, there was no uncertainty as to whether or not this was in the same condition as before. It was indisputably either gone or destroyed. Where do you get this idea that it's enough to say, well, maybe the expert may have altered it, and therefore that transforms it into the Williams analysis?
Well, I cannot say for sure that, I mean, all I can say is that we will never know.
Well, is that like a case where the police didn't take some evidence, say fingerprints, and you say we'll never know if there was a fingerprint of a third person because they didn't do fingerprint tests, they didn't put the powder around at the scene?
I think there was a representation that this gun was not an operatable firearm, a representation by counsel. I think when you look at what was actually done...
Well, wait, how does counsel know that?
Well, he doesn't say, he says, as an officer of the court, I can't tell you exactly how I know that, but I know that. The other thing is when...
I don't follow that.
That's what he said when he moved to be present at the testing.
I think it was actually the post testing hearing, but also...
Oh, so maybe his client told him or something.
But when you, that may be a fair inference, but when you look at what was actually done to get this gun to fire, obviously there were if you were in a gunfight, this is not the gun that you wanted to be holding. This gun, there were some Herculean efforts to get this gun to fire. And we don't know if there was somebody stuck a pliers in and did this, or if jamming that clip in there made it fire in a different manner.
You keep saying that, but why can't you ask the person who did the test that? Did you do this? Did you do that? Did you do anything?
We will never know if he decides not to disclose what he did or doesn't remember. We'll never know that. And also, he may not know whether jamming that clip in there to get the safety off made any kind of alteration to the gun.
I can see that on the last point, but I don't see how you can assume that somebody is going to testify falsely.
I'm not assuming. I'm just saying that
You said we'll never know if he did this or if he did that because he may choose not to disclose it.
if he doesn't disclose it, if he chooses not to disclose it, we have no way of determining that. And I'm not accusing him of doing that. I will say that his certificate did not provide a lot of information that I think probably would have been relevant, and that the defense found out about in the second test. But I cannot accuse him of anything specific. I'm just saying that we have no way of cross-examining and determining that, other than to ask him the question and assume he's going to be completely straight. And in these circumstances, I think the judge was correct.
Well, we're going to have to leave it there. You didn't get to your second point. You're going to have to rest on your...
I think it's well covered in the briefs.
Thank you.
Thank you.
Good morning. May it please the Court. My name is Macy Lee, and I represent the Commonwealth in our appeal. I think it should be made very clear to the Court, and it's my fault that I did not include the police report in our record appendix, but the Boston Police Report clearly states that upon the defendant's arrest on September 11, 2006, that in the glove box of the motor vehicle in which the defendant was arrested, from which he was arrested, the officers recovered a star 9mm obliterated serial number with the hammer in the cocked position. Ballistics responded. Detective Camper removed the firearm from the glove box, and one round was in the chamber, one round was in the magazine, which was inserted in the magazine weld of the firearm. So there was a magazine with this particular firearm, which correlates with the fingerprint test report that indicates there was a silver magazine on which fingerprint testing was done, and also correlates with Detective Camper's report that a Smith & Wesson magazine was with the evidence. It's not listed. I concede it's definitely not listed in the report. I'll be happy to provide a copy of the report to the Court after oral argument.
Were they found in the same place?
Yes. They're found. The magazine was in the gun. Was in the gun. As far as I can read from the police report, it was in the gun. There was a round in the magazine, and there was one in the chamber.
Is there anything that, it's a different point, but I'm just wondering, is there anything that identifies the magazine as a Smith & Wesson?
It does not in the report. I will concede that it's not listed in the property, certainly not, but it is definitely in the full narrative of the police report. Very specific that there was a magazine, there was a round in the chamber, and one in the magazine.
Why didn't, oh, go ahead.
In whose fingerprint was found on the magazine?
I don't believe there were any fingerprints found. There's, the tests were inconclusive.
Why didn't the Commonwealth comply with the order of the judge?
I do not
simplify matters so much.
I completely agree with you, and unfortunately I can't answer to that. But what I do know, however, is that...
That's really not acceptable. I mean, if there's an order, is ballistics so backlogged that it can't get to it, so you need a continuance after continuance? Did you not convey, did your office not convey to...
I completely agree with this Court. I agree that. I completely agree with you. I do. Unfortunately, I cannot answer in terms of what happened in Roxbury District Court. But what I do know, however, is that defense counsel...
Detective Camper himself was, the defense counsel wrote him. Himself.
That's what he says at the hearing. There's no letters produced to indicate. I mean, it's just for argument's sake. I mean, I don't know whether, in fact, he was indeed contacted. He said he made numerous phone calls, and as well as Greg Danis. I do not know because there was no evidentiary hearing. There was no evidence to support any of these arguments. In fact, defense counsel made tons of arguments that the gun was destroyed, that this was disastrous. There's nothing whatsoever in the record to support this. In fact, the gun was already manipulated because there was a round already in the chamber, hammer cocked at the time the gun was seized from the motor vehicle. So that's number one. And number two, I agree. Should the Commonwealth have behaved far more professionally in complying with the court order as opposed to waiting 4 months and then having the gun tested without defense expert? Yes, of course. But the bottom line is that does not result in bad faith. The defense counsel
Bad faith isn't, I mean, there's a lot of reasons why maybe Williams doesn't apply, but bad faith is not the test necessarily.
Well, it's not, but I respectfully disagree, Your Honor, because here we have a discovery sanction pursuant to Rule 14C. Well, some of the factors that need to be weighed by the court is whether or not there's surprise at trial. There is absolutely no surprise. There would be no surprise. I presume that defense counsel received this police report, that he knew that there was a gun. In fact, he didn't meet his burden because his affidavit attached to his motion to have his defense expert present doesn't even indicate that he believes that it was not a working firearm. He simply says that the government may or may not conduct tests or experiments in connection with the charges.
You may not what?
May or may not. He simply asserts in paragraph 4 that this is not in the record appendix. I will be again happy to provide this, although I think it was transmitted to this court.
The judge said that he wanted defense to be present.
Correct.
So what more do you need than a judge ordering it to be present? You're going to say, well, there wasn't really a very good reason for the judge to order it, so we're going to blow it off.
You're correct, Your Honor. But in terms of meeting his burden in requesting sanctions against the Commonwealth, his burden was not met. Again, he's not proven.
What's the point of having sanctions if you can blow off an order and the defense attorney can just say, well, I can't really show that I'm going to be surprised, therefore nothing happens? That just seems...
I agree with you. Again, I will not in any way justify or defend the Commonwealth's actions in the trial court. But however, the sanctions need to be tailored to cure any prejudice that could result from noncompliance. And here, there's been no prejudice whatsoever. There's been no prejudice shown.
Can I ask you this? I mean, it's very clear from the get-go in this case that operability is the only issue.
Correct.
And very clear in the motion that defendant filed to have his expert present, it says specifically, as physical manipulation of the firearm may be required to make the firearm a working firearm, the defendant is entitled to have access and ability to be present during that potentially destructive process, as crucial evidence may be lost without an opportunity to examine the same. So this is all laser beam focused on that very test and nothing else. So that's the whole case.
Correct.
And I take it you'll concede that this wasn't just a standard take the gun, fire the shot. There seems to have been more difficulty or more manipulation that was required to get this gun to fire.
Yes. In fact,
and that's not in the ballistics report.
That's not in the ballistics report, and it's definitely in the defense experts report.
Who was there after
he was there
for the
for
second test?
Right.
And noted that this was a problem.
Right. I think it was he was there March 9th, and I think the report came out March 8th. I could be wrong with that, but I think it's within days apart.
The test was done February 21st.
I'm sorry. The report was produced on March 8th. To defense counsel, and then the following day he was present. But this court has been very clear, as well as the appeals court, that minor changes, alterations of a gun does not necessarily make it inoperable.
But we don't know whether it's minor or major.
Again, I think based on the defense experts, the defense's very own expert, very neutral in tone, made no allegations that it was altered. He simply, his opinion was that it was not fired in the traditional way.
Has your office taken steps to avoid a recurrence of this type of issue?
I'm not aware of that, but I will certainly bring that to
I mean,
my
I
office's
know that
attention.
it's very busy and every assistant DA is terribly overworked in the district court, but district court cases sometimes are important. And they can come up to our level, and these things are so easily avoided.
I absolutely agree with you on it, but the bottom line is, again, there's no bad faith involved. The court noted
No what?
bad faith. I mean, Judge Bolton noted that inadvertence definitely occurred here, gross negligence
But
at
I'm
best.
accepting that it was inadvertent. There is no excuse for it.
Absolutely. Again, even based on prosecutorial misconduct or even egregious behavior by the police, it's not enough to essentially dismiss this case by suppressing every evidence.
But you can't basically say there was no evidentiary hearing and then say, but the judge found no bad faith.
You're right. You're correct.
So the judge didn't hold an evidentiary
You're
hearing,
correct.
so he was just relying, he didn't base his ruling on a finding of bad faith.
No, the best case would have been that Detective Camper was in court and testified, and as well as the defense expert as to what occurred and the reasons why the discovery order was not complied with. Yes, that perhaps that should have occurred, but because it didn't, you're correct. There is the motion judge's report findings are purely speculative, that there was inadvertence, even negligence, possibly bad faith, that there was alterations to the firearm. There's nothing in the record to support
What is your
any of that.
position on an evidentiary hearing?
I think it should have occurred.
Did the Commonwealth move for one?
I believe no.
And after the judge issued its ruling, didn't move for reconsideration and request a motion
I moved for
hearing?
reconsideration after.
And did you request a hearing at
I
that
did.
time?
And it was denied.
Okay, so what do you say should be the price paid for the government's apparent recklessness with regard to this?
I think that there are many ways that the motion judge could have tailored any possible prejudice, if there were any at all, here, limiting Detective Camper's testimony, suppressing the first report. There's so many ways. The defendants will have full cross-examination of Detective Camper at trial. There's so many ways that could have been, there's so many things that could have cured any possible prejudice versus suppressing all the evidence in the Commonwealth's case. And these factors were not considered by the motion judge at all.
What about just allowing in the evidence of the gun with the bullet in the chamber as supporting operability? I think
Yes. Yes, and there's plenty of cases.
That limitation.
Yes.
With
Fancy,
no ballistics at all.
stallions. Exactly. There are definitely cases that this court has upheld, as well as the appeals court. Stallions, Fancy are the two that I can think of where there's no testing, as you noted, Justice Duffley. And simply because the firearm was loaded, that's evidence of operability. So, I mean, here
It wouldn't
there's...
be a dismissal. It would just eliminate all the ballistics evidence.
Exactly.
So is your principle that the judge must cure all possible prejudice?
If there is any prejudice at this point.
And if the judge finds that there is no means to cure all possible prejudice, then do you agree that dismissal is then the only reasonable alternative?
No, because I don't think we need to reach that. There are so many cases in this Commonwealth where there are so many severe cases where the murder weapon in Dinkins was completely destroyed and lost. That case was not dismissed. There are cases where in Giantis, where the Commonwealth failed to reveal the identity of rebuttal witness. This court held that the trial judge properly cured that situation by limiting the witness's testimony. There's so many other...
Those cases involve a pretrial order of examination with the defendant being present?
I believe that, no, in terms of being present.
So why couldn't we simply affirm the judge and say that there was no abuse of discretion here because the Commonwealth violated a clear and direct order?
Because, again, there's so many factors that need to be weighed here that were not weighed. Again, I don't want to keep repeating myself.
But that's not my question. Can we affirm a judge and say that he did not abuse his discretion where the Commonwealth violated a clear and direct order of discovery?
No, not without considering all the factors that are necessary to determine whether or not that particular order was necessary to tailor or cure any possible prejudice. So no, it may not.
So it would be an abuse of discretion if the order did more than cure the prejudice?
Yes.
Is that what you're saying?
I mean, this court noted back just in December a few months ago in Carney and Frith, those dealt with punitive damages.
Pretty different cases.
They are very different, but I think this court was very clear that violations of discovery orders, it's not punitive, it's remedial in nature. And here, although
there's considerable remedial value in having a judge's order observed, especially an order as clear as this one. So if we were to remand the case for an evidentiary hearing and the judge were to consider all the factors and nevertheless say, well, I think that there is considerable remedial value here in having the Commonwealth observe these clear and direct orders, and I'm going to order that the evidence be suppressed, would he be acting within his discretion?
No, because again, by suppressing all the evidence, testimony, all the ballistics evidence, he would be in essence dismissing the entire case. And that would be an abuse of discretion because again, that's not ensuring a fair trial. That's not tailored to cure any possible prejudice. There's so many other remedial actions that would be available that would not result in the severe sanctions of all. Which would
I suppose one of them might be, as you suggested, the judge could simply, if the defendant requested, exclude all expert testimony from the Commonwealth.
Perhaps, yes. That would be a remedial action. I think well heard by the Commonwealth as a sanction.
Because
Yes.
here, I take it he excluded the gun and the testimony,
Yes.
which
So in essence, he dismissed the case because there's no evidence whatsoever except for the marijuana.
But if you exclude all expert testimony, you lose aneway.
Exactly.
So,
Well, I mean, you would have,
What did you say?
well, the thing is, I mean, he's charged with there are 5 charges, and there's marijuana and then the firearm. So if you exclude all testimony and ballistics evidence, essentially the Commonwealth has no case left.
No, I'm talking about the expert testimony.
Oh, yes, the expert, yes.
If you excluded that, you still have a case left.
Yes, yeah, I'm sorry, I thought you...
just said you could argue that the gun was
Yes.
operable because it was a bullet in the chamber.
Correct, I'm sorry, I misheard you. Unless the court has any other questions?
yeah, I've got one more. Let's imagine that there is an evidentiary hearing, and let's imagine that the judge does not find credible the ballistics expert, and therefore concludes that he can't really be sure whether or not this gun was altered. Then, do you agree that dismissal would be appropriate if he finds the expert not to be credible?
To dismiss the entire case?
Well, it's
To do
to
what he did here.
suppress the evidence.
Suppress the evidence? I don't know. I want to say no, because
Well,
I
at
don't...
that point, why wouldn't it be fair to go before the fact finder without
Right.
the expert testimony? With
True.
the gun and the evidence as to how it was found, and let the fact finder, because in the hypothetical Justice Gantz proposed, I think it would be making the judge the fact finder.
Correct. No, I think that would go to the weight of the evidence. And I think simply suppressing Detective Camper's testimony would be a remedial enough measure, as opposed to suppressing all the evidence.
Thank you, Counsel.
Thank you.